Hi, everybody. We're live. It's Elizabeth Matherne from Kuck Baxter's South Georgia office, joining you today to talk about the latest in immigration news. We'll give people a few minutes to join. I wanted to give you some updates on, I don't have a ton of updates on like Ukraine, the State of the Union address. There's a little bit coming out on like people calling for TPS for Ukrainians. Let's see. There was, this might be helpful to some people. There was a USCIS notice in response to a class action related to certain people who were denied adjustment under the Cuban Adjustment Act. That's a really interesting development and shows how litigation works. H-1B season is upon us. People are filing H-1Bs. Also, there is some information about the H-1B or USCIS cracking down on multiple registrations. So we've got some stuff that we can talk about. Of course, as always, you're welcome to ask me questions and I'll answer them live. Feel free to post your questions. Feel free to say hi. Give me a little bit of information on where you are watching from. It's always so fun to see you guys say hi and say where you're watching from and all of that. Now, I know that there was a decision on, it wasn't a decision, it was a decision on a stay request on the Gomez case, I think. I saw that on Twitter not too long ago. I am not going to give you like the ins and outs of that because I'm not part of the litigation team. I just sort of keep up with, the talks that are going on, and I try to listen in so that I can give you some advice, but and information on diversity visa litigation. But I am not your point person for that. For your real specific questions about diversity visa litigation, make sure you tune in to Mr. Kuck's Facebook Live. They do the impact litigation Facebook Live. At some point, it used to be on Monday nights. I'm not sure if it still is, but I know Mr. Kuck, who used to do Wednesday Facebook Live at 2 p.m., is now doing Wednesday at 5 p.m. So make sure you tune in to Mr. Kuck's Facebook Live once a week to get the latest on the litigation cases and things like that. I'm your go-to for your questions related to family, removal defense, humanitarian, asylum, all of that good stuff. And also for the latest news tidbits of what's going on in the immigration world. So let's jump right in. I see a few people commenting. Samba, Amadou, thank you so much for saying hi. Alma has a question. Let's see if we can get to your question, Alma. Okay, Samba, thank you for your question. Let me take Alma's first and then we'll move to yours. Great. Keep the questions rolling in. That'll give us something to talk about. I love seeing you guys post. Thank you so much, everybody, for joining. And by the way, I don't know if I mentioned, but I'm in our South Georgia office, which is halfway between Tifton and Valdosta in Adel, Georgia. And we're right off I-75. So if you're a local to us anywhere in North Florida or South Georgia, please feel free to look us up. Stop by the office. Feel free to say hi. All right. So can someone who has DACA since 16 years old, never left, let it expire, adjust status through a permanent resident spouse? Let their DACA expire? Is that what you're saying? They let their DACA lapse, so they didn't renew their DACA? Never let it expire. Sorry. Okay, they never let it expire. So they have been in some sort of deferred status since 16. What you don't say here is whether they entered with inspection at any point, whether they used advanced parole or if they entered with a visa. Can they adjust through a permanent resident spouse? So right now, I think permanent resident spouses is still current. So in theory, yes, they could. If someone gets DACA at 16, they don't accumulate unlawful presence for purposes of the 3 or 10-year unlawful presence bar. They could still accumulate unlawful presence for the calculation of the permanent bar. So I'd want to make sure that they only had one entry. So in theory, yes, Alma, in theory, yes, that person could. The key pieces of information, okay, legal entry, and they kept it renewed. Okay, yeah, so this is looking good. This is a possibility for sure. Alma, I think that's a great question because a lot of people may be in that situation. And yes, that is a possibility. We've seen that a similar fact pattern also work well with employment-based visas because people didn't accumulate unlawful presence, so they wouldn't be ineligible for an employment-based petition that they could then use to adjust. So that is a really key point of having that DACA, entering with inspection, having that DACA since before you were 18 years old. All right, so let's move on. Samba, you have a question. How to do my case is denied past 4 to 5 years. So your case was denied. She leave me because of U.S. I'm not divorced. Okay. What I'm gathering from your question is that you tried to adjust status based on marriage and that it was denied 4 or 5 years ago and you're wondering what can be done. I need to know more information. But let me talk generally about adjustment cases in general, maybe that have had a denial. In theory, if your adjustment is denied, you can appeal it or you can refile it. That's always an option. The denial doesn't necessarily mean that you can't do either of those things, right? You can appeal the decision and say that you think it was legally invalid, or do, like an argument why the law was applied incorrectly in your case, that the facts were misunderstood or misapplied. You could also refile. One of the situations that would make things more tricky, a lot more tricky, is if your denial was based on some sort of like a fraud finding. So then you might have a harder time. And I'm setting that aside for what I'm saying generally about adjustment cases. Now, you're not divorced, and I take it that you're probably not together. So refiling may not be an option. Something that we try to look into, and I'd have to do a consultation with someone specifically to see if this was applicable, would be I'd look at VAWA, which is Violence Against Women Act, but it's not just for women. I've talked about it before in other Facebook Lives. Men definitely can be the victims of or survivors of abandonment and abuse. Emotional abuse does count, but it's not required that you have filed a police report. Some people think it is. There are certain limitations to when you can file VAWA. What VAWA is a self-petition for adjustment, saying that I would have been able to adjust based on marriage, but for the abuse. So it can be done in secret. Your spouse doesn't need to know about it, but there are limitations. For example, you have to meet a certain abuse threshold. You have to meet a certain burden of proof, and you cannot have been divorced more than 2 years. So the divorce cannot have been final more than 2 years. So because you say you haven't yet divorced, that makes me think of VAWA maybe being a possibility still if you're not still together. So anyway, sounds like there may be more that you could talk with an attorney about, maybe dig a little deeper and figure out if there's something else that can be done in your case. That being said, I don't think just because you had your case denied 4 or 5 years ago that there's nothing that can be done. That's not a bar in and of itself. So it does make your situation maybe more tricky, but not impossible. So I encourage you to reach out and schedule a consultation. If you haven't already, let's try to talk and see if we can find something that can be done in your case. Okay, Angu. Can my wife qualify for PIP if she entered the U.S. illegally twice. First was in 99 and wasn't caught. However, she left and re-entered the country in 2006, and she was caught, and our son was born at. What you're talking about is the multiple entries, like entering without inspection, accumulating over 1 year of unlawful presence, leaving, coming back in again without permission. So, and then she was caught, maybe returned and re-entered again. So what we're looking at is potentially the permanent bar, right? Permanent bar is not necessarily permanent. It just means that you have to wait it outside the U.S. for 10 years. There's no waiver for it. PIP is parole in place, and it can be used for people who entered without inspection and they have an immediate relative that's in the military, to give them that entry with inspection that can be used to adjust. The problem in a case with the permanent bar is parole in place doesn't waive that inadmissibility bar, the permanent bar, because it's unwaivable. The only way you can get over the permanent bar is to sit outside the country. Or if you have a VAWA claim, and it's tied to the abuse, it can sometimes be forgiven or exempted. So Angu, I'm not feeling super confident that PIP is going to be the answer, because PIP is going to provide your wife potentially with 1 year of parole and entry with inspection, but then what, right? She's not going to be able to use that parole in place to then adjust because of the permanent bar. So some other decision, some other action would have to be taken. So we can talk more about that. You see people use deferred action in a similar way, or even maybe the parole could be renewed, but you're not going to get yourself to green card holder with just that. You see what I'm saying? So yeah, right, I know. Okay, so Angus says, well, she was only caught once. Right, but you have a child that was born in the U.S. before she was caught re-entering. So it's inherent that she was in the U.S. before she left and came back. So and you got to be honest on these entries and exits on your forms. So I think we're in a bad place on that. But who knows? She might have something else. Permanent bar makes things really, really difficult, really, really complicated. You're welcome. That's one of the things that many people think has really screwed up our immigration system and like trapped people here in the U.S., not enabling them to adjust status, despite years and years and years of being really well contributing members of society. So I always hate talking about the permanent bar because it's so frustrating. But it also is really important that we use the exact dates and we confirm a permanent bar analysis. Just to flag for you a few things, like if the person didn't accumulate the 1 year prior to leaving and re-entering, they wouldn't be subject to the permanent bar. Or if the entries and exits maybe were prior to 1997 when that law was enacted, they may not be subject to the permanent bar. So just so you know, there are a few things that make it maybe not applicable in some cases. A lot of people call that the multiple entry bar, and it isn't just simply a multiple entry bar. It's a little bit more complicated. So make sure if you think that might apply to you that you get it evaluated. It's worth the time of an attorney reviewing the facts of the exact entries and exits, so you have peace of mind. All right, so Edith says she applied for her DACA renewal a week ago. It expires in the end of May. Also applied the same day for advanced parole. I know the timeline is almost 6 months for, sorry, I swallowed some dust, I think. Sorry, folks. Okay, if my DACA does not get approved in time, is there anything I can do to make sure my DACA is active just in case the advanced parole gets approved in the meantime? Um, the short answer to this is do not travel with an expired DACA. If your advanced parole gets approved and your DACA is still in limbo, meaning that it's still pending, I would just recommend you don't use that advanced parole. You're just going to have to apply again when you get your DACA card renewed. I mean, yeah, if this were like a lawful permanent resident situation, you know, then we would be able to argue that, oh, the person's always a lawful permanent resident. They can get it even while their card is pending, even if it's expired, they're still a lawful permanent resident, and they could get a stamp and they could still travel. That's not necessarily the case with DACA. So, you know, like we caution people, don't ever travel before your advanced parole window, because then you're like abandoning your DACA. Don't travel when you don't have a, don't travel don't travel outside of the current dates on your DACA card. I just would say you're probably just going to have to wait for those two things to sync up. Now, I mean, it is possible that it all works out, but as far as some sort of quick fix like a stamp, or traveling with the receipts for DACA, I wouldn't risk it. I certainly wouldn't risk it. Okay, Daniela, but thank you for asking, Edith. I think that's a really great question that a lot of people can benefit from. So it provides a lot of clarity for people in a similar situation. And I know that everybody has heard me recommend that if you have DACA and you haven't gotten your advanced parole, traveled out and come back in, if you entered with inspection previously, if you entered without inspection previously, now is the time to do it, okay? We really need to do that. With the way advanced parole for TPS holders has started to be being treated differently, DACA advanced parole is still being treated as an entry for purposes of adjustment. I think we just need to go ahead and move through, you know, those petitions, because I'm worried that that policy is going to change, follow suit as the TPS policies have changed. Okay, so Daniela Sanchez is asking about DACA. I think you're asking like what's going on with DACA. So far, we haven't heard anything. Remember that notice and comment period ended, what was it, December 29th of last year? We were still waiting for USCIS to update their guidance, and for the details of DACA to be added to the Federal Register. Haven't seen either of those things. Really frustrated. Initial DACAs are still frozen. You can apply, but you don't know what's going to happen with that. So many people are recommending you just don't. DACA renewals are being processed, and DACA advanced paroles are being processed. So that's sort of where we are. We're in a holding pattern. And I know that a lot of advocates are pushing still for path to citizenship for DACA holders to be addressed by the government. So far, I haven't seen anything realistic on any of that. Okay, so it looks like we've burned through a lot of the questions. Thank you so much for everybody who's joined and is watching and asking questions and saying hello. It's always so great to see y'all. Let me run through a few things. Build Back Better. Danielle is asking about Build Back Better. I know that I saw after the State of the Union address, several people, you know, tweeting and posting about the State of the Union address barely mentioned immigration. And there was some sort of line in there about we still need to protect dreamers and farm workers and healthcare workers or something, but no real hopeful, clear, solid statements about doing anything. So Build Back Better is, in my opinion, dead. I cannot foresee that within the limits of my imagination and my experience in watching immigration policy and law, I don't see Build Back Better coming back in its totality. And I know a lot of people have talked about Build Back Better coming back in portions. I don't necessarily see that happening either. I mean, I feel like there's a lot going on now, especially with Ukraine and Russia, and the ramifications for sort of the dominoes around the world falling. I can't see, even if the Democrats did take it up, trying to push it through because they currently hold the majority, technical majority. I can't foresee them having the guts to even try it, let alone being able to like get organized and pull something together. There's just, you know, at some point, like there is no facts upon which to base like that hope, right? At this point. So it's super disappointing to me. And I'm sure it is to many, many people, especially the families that are stuck because of it. Okay. How to determine if the permanent bar applies. In order to divulge the most appropriate facts and a path to green card or citizenship, not saying there are untruths offered, but how to present info. In order to divulge, I think what you're asking is like how to thread that needle, how to sort of maybe get around or decide what to disclose or what not to disclose. I am cut from the cloth that you just have to tell it, like the truth is the truth. Now, what decisions you make on an application, I guess, would be up to you, what you disclose and what you don't disclose. But if you're working with an attorney, me specifically, I want to know what actually happened. And I feel like we're always in a much better position of selecting a course of action based on the truth. So that's all we can do. The truth shall set you free in a way, right? So in my mind, you just gotta go with the truth. And if the permanent bar applies, and there's no way to get around it, no exemptions that you qualify for, and then what you're looking at is an inability to adjust unless you sit out for 10 years. And I know people that have sat out for 10 years. And, you know, it seems like a really long time. And it is a really long time, especially if you're separated from your family. But people have done it. So that is not to say that it's a correct policy or that the law shouldn't change. But you're not, I guess, necessarily bad, a bunch of bad options. But it is, in theory, an option. Okay. Joe wants my email, please. Okay, I will message you that. You're also welcome to send me a direct message, and I'll see if I can get it through whatever platform you're watching. Thanks so much for your interest. All right, folks, let me just put in the chat the South Georgia office contact information. If you want to schedule a consultation with me directly, you can call us. You can also self-book. It's so good. You just go on our website, schedule an appointment, pick the attorney that you want to do a consultation with, and pick a time. And then you just fill in your information. So easy. I prefer to self-book all the appointments that I can self-book. Not that I don't love talking to people, but it's just so easy that I can do it as soon as I think about it, go in, book, and it's done. It's on the calendar. All right, so let's see. A lot of people have been asking questions in the immigration attorney world about what should people do if they're trapped in Ukraine, trying to get out of Ukraine. If they have U.S. citizen relatives, how can they get them here and get them safe? All of that. That is, I don't know that we have anybody necessarily interested in that, but I'll just give you a few bullets. We know that the people who are going to Poland, Warsaw is committed to trying to help the U.S. consulate in Warsaw is committed to helping as many people as possible. And there is a very impactful statement about that. They remember in World War II when people were fleeing from Poland and maybe they didn't receive the help they should have received. So they are trying to rewrite the future history in any way that they can. So it's very, very, I don't know, moving to see people rallying around Ukrainians. On the other hand, we have many clients who are Russian. Maybe they have a U.S. citizen fiance, a U.S. citizen immediate relative. It's going to be a lot harder in a way maybe to get processed for anything out of Russia. We know that the airlines are not flying out of Russia, things like that, like things are shutting down. I do not know anything about land borders, what's happening there. So that may be an option. So, you know, it's changing day by day. I don't have a ton to report on that. So it's more probably specific factual questions that we might be able to answer one-on-one for whatever somebody's going through and trying to expedite their path to safety. All right. I did mention it's H-1B registration process. Make sure that if you were selected that you're getting your stuff together because there's a very short window for applying. Remember that the USCIS did something really weird. They will no longer accept single combined fee payment for certain forms, and that includes H-1B forms. So now you have to submit everything separately. And oh, I said I was going to mention the Cuban Adjustment Act and the denials and the policy that came out. I see we've got a few more questions rolling in. Let me get to those. And then before we wrap up, which should be really soon, I'll just give you a bullet point about the Cuban Adjustment Act denials and whether you should refile if that applies to you. Okay, so Emily Dietz is asking, what's the difference between an administratively closed immigration and a deportation order? Okay, that's a great question that could probably help a lot of people, Emily. So thank you for asking that. Administrative closure is kind of like putting a case on ice or on pause, like frozen. It is not done away with, and you do not have a deportation order. If at any point the government or you wanted to reopen the case, you could ask the court to reopen it, meaning like it's not closed, it's not put to bed completely, it's just kind of put away, put to sleep, frozen. A termination means that it's all the way closed. A dismissal means it's all the way closed. Could the government, the Office of Chief Counsel, the immigration prosecutors, could they file something new against you? Yes, in theory they could, but they would have to go through the process of initiating new proceedings. With an administrative closure, the proceedings are already there, they're just temporarily put away. So it's great for many cases in the instance that you don't have to go to court because it's put away, but it is not like a final disposition that you can kind of hang your hat on, right? You have to keep your address updated. If at any time they want to reopen, reinstitute, get things rolling again, then you want to make sure that your address is on file so you can get that information. If, for example, you have a pending application like a cancellation of removal and you get your case administratively closed, remember how I said it's not like a final throwing out of the case, you should be able to continue renewing your work permit based on an administrative closure because it's not finally closed, it's just temporarily closed. If you had to withdraw your application for it to be administratively closed, that's another scenario. So administrative closure has some definite benefits. A deportation order is an order for your deportation. just like the name says. So it's saying like ICE has an order to take you and remove you from the United States. A deportation order isn't final necessarily if it's being appealed. But if you miss that appeal window, if you haven't attempted to reopen it, it is a final order and it can be used to remove you should you come in contact with law enforcement, immigration authorities. The thing about a deportation order as well is it can be reinstated. So if you're deported and you come back and you're caught by ICE, they can use that old deportation order to just turn you around and put you back out of the country. That's called reinstatement. Reinstatement offers you very little options. It offers you like only the option to be able to say, wait, I'm in fear for my life. I need a reasonable fear hearing. If you pass that, then you could apply for an asylum-like application. It has a different level of burden and a different name. But a deportation order is obviously more final and gives the government orders to be able to remove you. One more thing about a deportation order is you can file for a stay of deportation, which gives ICE, immigration removal authorities, the option to pause the judge's order to remove you. So sometimes, and this was used many years ago more, like under the Obama administration, we saw stays used more frequently. You have a deportation order that says you could be removed. Maybe you've got something really serious going on with your family, like a really sick U.S. citizen relative, and you can show that proof that you need to be the caregiver. Maybe the person has a terminal illness, terminal diagnosis. It's not going to be forever. It's just going to be for this period of time where this person needs caregiving. ICE may give you a stay of deportation, meaning they'll put it on pause, give you a period of time to wrap up this situation, deal with the humanitarian situation. You get a work permit in the meantime. You have to keep checking in, but it's like a pause on the deportation order. So in that effect, it can be paused, sort of like just taking a temporary reprieve. All right, so Emily asked a follow-up question. Is it easy to reopen and terminate a case that's administratively closed? In theory, yeah. In theory, yes, it's fairly easy, but you have to have a certain reason, not just for the heck of it. If, for example, you have like a new adjustment application pending, or a newly available application for relief, then that might be a really easy way to get it reopened. Also, we've got something called prosecutorial discretion, and that is guidance from the President, Department of Homeland Security, telling the Office of Chief Counsel that they can use their discretion, and it should be applied to like reopening these cases to try to help people move cases along. So prosecutorial discretion is in theory making it easier to reopen, terminate an administratively closed case. We do a lot of that. Sometimes it has to do with filing like a 601A waiver, etc. So yeah, the short answer is yes, pretty easy. It's all relative. Okay, FYI, in country via Mexico for 20 years, in letter 20 years and considering marriage undocumented, never perm barred, no, nor never apprehended. Okay, so then if a person has been out of the country for 20 years, in country via Mexico, in the US, okay, all right. So Roberto, we have to know if the person entered with inspection or not. If they didn't enter with inspection, then we've got to look at the waiver process. If they've got a qualifying relative for a waiver. So if they're married to a U.S. citizen or a lawful permanent resident, then they may have a qualifying relative for a waiver. It's called a 601A waiver. If the only thing that they're dealing with here in the U.S. is a ground of inadmissibility of unlawful presence, then that's a really good potential avenue. So yeah, I think that might be a good option. I'd have to know a little bit more, but worth looking into for you for sure. All right, Sonia, is there a time limit for someone to apply for a U visa after the incident? That is a great question. Thank you, Sonia. We get that. I see that a lot. The answer is there is no time limit on the immigration side of things. Some police departments or other people who are a law enforcement agency that's enabled to sign a U visa certification may have their own policy that they will only sign U visas within 6 months of the person being charged with the crime, or 1 year, or some number they've come up with. Now, there was I think maybe Austin or San Antonio, there was a town in Texas that had a group of people. They had a policy, which was a very, very short window to sign supplement Bs. The community helped educate law enforcement on, like, why that would sort of be unfair or make people ineligible for something that they otherwise qualified for, and had assisted law enforcement and helped them get a conviction. And the police department changed the policy. We also see that departments that have for a long time had no time limit have changed policies the other way, right? Like, they now have a deadline. So policies can change all the time. If you think you're eligible for a U visa, the best thing to do is talk to an attorney in the area where the incident occurred, immigration attorney. If it's like a little town and there's not an immigration attorney there, try, someone that may work in U visas, immigration attorney that may work in U visas in that state. So the thing that I'm saying is, don't wait, do it now, because the policy now may enable you to get that certification signed, and it may change in 6 months. If there's a new sheriff elected, and same goes with if you've already been told no. If there's a new sheriff in town, they can do what they want, or a new district attorney, they can change the policy. So, but on the immigration side of things, nope. If you get that certification signed, you must use it within 6 months to file your U visa. But I know that I personally have gotten a U visa granted for a crime that was more than 15 years old. So it's totally possible. So I think that answers your question. You're very welcome. All right, have any Russian asylum grounds now? I'm watching this. I know that I saw large demonstrations. I know that people were also seeing videos that I'm not sure if they've been authenticated, but of Russian soldiers turning themselves in Ukraine, kind of like surrendering. Large demonstrations in Russia of people protesting the war or the invasion. I haven't seen anything necessarily documented on those protesters being persecuted. But I mean, I imagine there is some persecution going on. I imagine there is repression of political opinion, consequences for expressing political opinions that are contrary to the head of state's actions. Sorry, the train. If we're on long enough, you will hear the train go by. So I don't know, Russian asylum grounds right now. I haven't seen anything concrete that makes me think, oh yeah, that'd be a great case. But of course, we're not getting all the information, and what has happened to, someone may absolutely constitute grounds for asylum. So it's possible. It's possible. I know that what has happened to journalists and other opposition or opponents, political opponents, seems to me like they've made would be sufficient for asylum. So, all right, folks. Well, I got to run. Thank you so much for joining me today. It was so nice to spend time with you and talk about all things immigration. Oh, I just remembered. I said I was going to mention about the Cuban Adjustment Act. So there were certain Cuban nationals who were admitted into the U.S. like some were paroled, and then others were put on supervised release or something like that. I'm not quite remembering the details of the case. Point being is that they were allowed and admitted into the U.S. through actions of immigration authorities. There have been people whose applications for adjustment of status were denied. If you're not familiar with the Cuban Adjustment Act, they have to have been here for 1 year, admitted through parole, and then they can get their green card as long as they don't have certain other inadmissibilities. A lot of cases were denied for people who weren't given that parole stamp, or the stamp wasn't like the right parole, but they were processed into the country, and they were given, you know, whatever documentation they were given. Those people have now been instructed by USCIS, whose cases were denied due to a lack of parole. They've been instructed to file an I-290B for up to 1 year, or a new I-485, because they now realize that they're not saying this, but they realize that those denials were stupid, and that they messed up. So people in that situation need to refile, or if they're still within 1 year of getting that denial, they need to file the appeal. An I-290B is like filing fees like $900 and something. So I guess compared to the $1,225, it may still be cheaper, but it would be an important thing for you to take action on if that applies to you or anyone you know. That is time sensitive. You know, it just came out, need to take action. Get your adjustment processed as soon as possible. And that is another example of how litigation works. I know that there's a good firm in South Florida that led the charge on that litigation that has resulted in this policy change and announcement by USCIS. So litigation works, folks. We have to hold the government's feet to the fire, or else they will forget who pays their salaries, which is us. All right, gotta run. Have a great day. Take care, everybody. I'll see you next Thursday. Bye.